Hi, everyone. My name is AJ Jahanian here. I am an associate attorney with Beaumont Tashjian, and today I'm here with Amy Dankel with FirstService Residential. She's, of course, an esteemed community association manager, and we're here today to discuss AB 3182 and all of its implications and consequences, and what we need to do to get our associations up to speed. And Amy has the unique position to be able to present some of those more pressing questions that our community associations may have.
Yeah, so what is the basic gist of AB 3182?
Well, what it basically says on its face is that starting January 1st, 2021, if your governing documents, such as your CCNRs or even any rules or regulations, if they have any restrictions that quote unquote prohibit or unreasonably restrict rentals in your community, those provisions are now going to be void and unenforceable. And if a board was to enforce one of those unreasonable provisions, they could be subject to a $1,000 civil penalty per challenge. So what that means essentially is that no longer can you impose certain restrictions regarding rentals, such as occupancy requirements, which is a requirement that you own the property before for a period of time before you're able to rent. Certain minimum lease terms are now prohibited. Rental caps might be prohibited, except for two exceptions. So the association can still enforce a 30-day minimum lease term for each unit, and it can still impose a 25% rental cap, meaning that no less than 25%, no more than 25% rentals are in the community at any given time. But you can't go less than 25% either. So other than that, beginning by December 31st, 2021, the association has to amend its governing documents. That's another provision of the law. So even though your provisions might become void starting January, you also have only until December 31st to amend the documents to be up to speed.
So what should boards do to prepare for January 1st?
Well, we recommend first that boards consult with their legal counsel to review the governing documents and determine if they even need to amend. They may not have any rental restrictions that violate this new law. For example, they may not have a 1-year minimum lease term requirement, which would violate AB 3182, in which case they may not have to do anything. But if they do, for example, if they have minimum lease terms that are greater than 30 days or their rental caps are less than 25%, we strongly recommend that we start the amendment process as soon as possible. And that means getting the governing documents in line with the law so that they are not violating AB 3182.
Can the association just adopt a rule change to comply via 28-day comment period, or should it go through an amendment/voting process?
Well, yes and no. The safest approach we recommend really is to amend the CCNRs because rental restrictions are very prohibitive. They limit what you can do with your property, and of course, anything that's prohibitive is subject to challenge if it's not put to a vote, particularly rental restrictions. And so that means really they should be amended. And the text of the law says to amend the governing documents. So it sounds like, although it's unclear, that a CCNR amendment is really the way to go. However, of course, that creates issues because an amendment is expensive because it requires a vote, it requires secret balloting procedures, and it takes time. So there are certain options that the board can consider other than the CCNR amendment. So if a CCNR amendment is not feasible because the owners are not participating in the vote, or you're just not able to get the amendment to pass, you can consider doing a rule change at that point. But at least you've shown that you've tried to go through the amendment process in case there is a challenge at some point.
So what if their association can't get enough votes to pass the document?
Yeah, so again, that's kind of the problem with this law is it didn't take into consideration the fact that there is a great deal of voter apathy in our communities. People just kind of are either happy with the status quo or have other things going on. And so the key thing is, again, to show that you've gone through the exercise at least, and this is assuming, again, that the legislation isn't cleaned up at some point to clarify on this issue.
Mhm.
But, at that point, really, you can consider a rule change at that juncture. And, that can act as kind of a temporary stopgap until we either get cleanup legislation or until you're able to adopt the CC&R amendment and get enough votes for it to pass.
Okay. So does AB 3182 apply to subleasing?
So no, the text of the law really doesn't discuss subleasing with specificity. So associations can continue to prohibit subleasing because the law, again, really only applies to leases. However, if we're talking about a stock cooperative, shareholders are subleasing because they own a share of stock and then they are leasing the units. So in that case, you would say that the law does apply to subleasing, and you should apply reasonable restrictions to subleasing for a stock cooperative.
Okay, yeah, that makes sense. Do new rental restrictions apply to all homeowners?
So no, the rental caps only apply to new owners who acquire title after the restriction is recorded. So, in other words, if the association is at its maximum number of rentals per the cap, so the association has a 25% rental cap, let's say, the current owners would be grandfathered in, even if that means they're above the cap. So they wouldn't be subject to that because it's a prohibition on rentals, and the law says that the prohibitions don't apply to current owners. So it would apply to new owners that acquire title after the amendment is passed, and then at that point you can enforce it. And of course, if the current owners have leases, but those leases expire, then they would then fall subject to the cap potentially.
Okay. All right. Well, thank you. That's all the questions I have for now.
All right. Well, I hope that helped clarify some of the more basic questions you have. But of course, if you guys have any other questions, feel free to reach out to us, and we'll try to help guide you guys through this complicated process.
Thank you, AJ.
Thank you, Amy. Take care.